and can file a patent, can prosecute it, and can get the grant of the patent. So steps have been elaborated to you. And then after that, I explained some forms that are mandatory to be filed along with your innovation. And yeah, some people were interested for like e-filing. So forms are there. So e-filing procedure can also be done, but it is a little bit more elaborate process as compared to paper filing. Then we explain the basics of claim drafting. So the body of the patent application is basically the claims and the description. So how to write your description and how to draft your claims so that it could cover your innovation as well as it should not infringe anyone's innovation. So in that way, drafting has been explained. If anybody has any query to ask or to give any inputs, because now you all are very learned faculty members, and you can also provide me some suggestions about your innovation so that it could be protected. And students who are there in the session, they can also ask a question, or they can also have, if any doubt in the yesterday's session, they can clarify it right now. Or I will proceed today with some of the patents which have been granted by Indian Patent Office, and patents were related to the mechanical engineering domain. Okay. So if somebody wish to provide any input, they can provide it right now, or otherwise I will proceed. So what should we do? To
Uh,
discuss something or go on?
yeah, I think they will ask in between if the
Okay,
participant will fill.
fine, sure. So I'm sharing my screen to you. Please let me know when it is visible to all of you. Is my screen visible?
Yes, ma'am.
And I think I'm perfectly audible to all of you.
Yes, ma'am.
Okay, then let's start. So today I'm going to discuss a patent application which has been granted, and this patent application has been filed by a firm from Pune only, and this firm has got it granted within a very short span of time. Their application was drafted well. I think many modifications they have done in the past. There are lots of documents that they had submitted, and the title of innovation of their patent was a mechanical assembly for vehicles. Okay. So this was a patent of a Pune-based firm only. So this is the matter that they have disclosed in the patent application. So how they have drafted, and so exactly you can, this is just an example that you all can follow, because this has been granted, they have faced all oppositions, they have justified their innovation, and later on they got the grant of the patent. So they have written the field of innovation like this. They have written that the present subject matter described herein, it relates to assembly for vehicles. Okay. So simply meaning they have written here exactly what they are doing. It is a mechanical assembly for vehicles that they have written, and then they have further described that term vehicle used in the description henceforth may refer to a two-wheeled vehicle, essentially a motorcycle or a bike. See here, they have exactly defined that this is a two-wheeler and could be a motorcycle or bike. So definitely their innovation is narrow, but they are not infringing any other. So if suppose they could have just written mechanical assembly for vehicles, then somebody else who has already got a patent for such kind of innovation for a four-wheeler may sue the party for infringement. It could have happened. So they have given a proper scenario of their innovation. So students, especially the innovators, startups, should write the field of innovation like this, so that their patent application must go without much objections. This is important, that you should specify, not too broad. So field of innovation should be written like this. Then comes the background of invention. Just after this, background has to be written in such a way that what has been done in the past, what is the background, what is the need of doing. Whenever we see that in the past this is not being done, so simply meaning not being done, so my work is novel. What work I'm presenting to the Indian Patent Office? and want the grant of that patent has never been done in the past. So that's why we have to properly state the background of innovation. Then only you can find that where is the scope. I think at the last I will give you some more highlights if time is there about the patent search, how it is done. So patent search must be done here. And then after doing patent search, you have to cite some of the patent. Give the examples of some of the patent applications that you have searched that are actually relates to your innovation. And you have to say, yeah, yes, this innovation has been done earlier in the past, but they have not done this innovative feature. This is still left. There is a scope, or whatever has been done in the past has some loopholes. It is not actually meeting the requirement, and there's still a scope of adding the innovative features. This is very important to be written. What they have written in their background is like a two-wheeler vehicle failed to provide a comfortable drive to a rider. So this is the scope that they are writing. Here, whenever you write, actually they have not cited much of the patent application examples, or they have not given the reference of patent applications, but it is mandatory. Nowadays, it is very mandatory so that patent examiner will become like more satisfied with your background. So again, they have written the vehicle do not even ensure safety to the rider. Rider faces the challenge created by the environment because like lot of winds, lot of dust may come to them. Challenges are what? Dust, chilled breeze, rain, or sunlight. These are the environmental challenges. Okay. So the rider may face discomfort and may suffer from wind burns, sunburns, eye, vision, weakness, and fatigue. This may happen. So there is a scope that innovator may add the innovative features and make it more comfortable for the rider. Okay? So some patent search reports must be given here. That US patent number, this, describe an invention comprising this kind of work. Again, they can write more and more examples like another US Australian patent number, this, describe an invention comprising this, this. But exactly this point was never covered, and still there are chances. If suppose the same innovation has been done in your case, then you have to find what exactly they have done and what innovative feature is still left to be done. Suppose they have made the same mechanical assembly, but not done in a way to protect it perfectly, and still you can give a more innovative advancement. You can give a more comfortable solution. So you can write here. There's still a scope. Those mentioned innovation do not solve the problem to the full extent because they may have this loophole. They may not included this. There is still a scope, and it could be made for the improved version of the mechanical assembly. So then at the last, your statement should be like this: how our innovation is novel, how it is new, and how it is technically advanced over the existing products. This justification is very important, and you can cite some example with like with reference to this US patent number. My innovation is different with this. So how do you elaborate? This is very important. So because objection comes here only whenever patent is being examined. I have replied to many of the like reply to patent office regarding the first examination report. So in that I have observed that many objections were just about the novelty, and they have given the reference exactly that in this patent number the innovation matches with your innovation. So what we did, we exactly gone through perfectly, mapped their claim. There is a term called as a claim mapping. In that, we exactly map the components that have been used, how they have actually did the procedure for fixing them, and what are the loopholes, what are the still the shortcomings in that. And then we write down our innovation, how they are better with respect to every component, or how they are different with respect to all components. Clear? So this point comes a very important part, like how to answer the patent office. So I think you all are very technical person, and you all know it very well how your innovation is different. But you know how to reply to the patent office in a very legal way is very important here. Yeah. So, in the reply, basically the objection come with respect to novelty, and it is infringing others because they are similar to all. You have to state in a you have to go deep dive inside your innovation and write that this component how they are different, and also during pleading, these document must be ready. So, what I suggest to all of you, if the students have been are joining, whenever you do any innovation, prepare a perfectly made lab notebook, and whatever you do on a daily basis, jot it down with photographs, with drawings, sketches, with all the data written nicely. Even if handwritten data is even more reliable. Patent office normally consider it as a more reliable proof. And then you put your signatures, get the signature of your guide or the mentor, and keep it as a document. You can have lot many lab notebooks, but everything, remember, everything must be documented whenever you are thinking of filing a patent application, because that is a proof that on that day, on this time, you have actually performed and got this data, and this data is yours. And in India, as a first to file system, there should be enough documentary evidence that this has been done first by you, later by others. Whenever you are able to prove that, because you know, granting a patent is not so easy, because there are a lot of competitions. So if you prepare well in advance, it will be more easy. And yes, some legal terminologies are there, so you can take help of some legal person, any patent agent. They can help you in drafting in the perfectly legal way, and it could be answered, because there are many sections, subsections in the patent laws that support your project. So within which section, within which subsection you can justify, this become important. So background of invention, why I'm stressing so much, because this is a background of grant of your patent application. Then comes the next point, that is, just a minute, summary of invention. Summary means, you can see, you have to write everything about your innovation in detail. There is no any way of hiding the innovation in any way. You have to jot down, write down perfectly everything. See what, how they have written. They have written that summary is providing all aspects regarding to the mechanical assembly, which are further described in the detailed description. The summary provide all the essential feature, all the scope of the subject matter, and how did you implement the innovation, that has to be given here. Suppose here they have written, the mechanical assembly for vehicles comprise a windshield comprising a glass window connected in the center of the windshield in the airtight manner. Windshield may be positioned above and in front of the vehicle body. This is very important, that where will you position it, that you have to write in your summary. Exactly depict it. How do you imagine? Every imagination must be written on paper. Windshield will, it's made up of which material? Acrylic material, or it may be transparent. It may not be transparent. Word, you can just see the words they have written. They may be transparent, so they can prepare even a non-transparent one or a translucent one. Clear? So translucent one, because non-transparent one will not work. So it could be little bit translucent, or it may be totally transparent. And also it contain a wiper connected to the motor of the vehicle for wiping the glass window. So everything has been written here. Then another implementation means, because they have prepared this mechanical assembly by three ways, but here the purpose is to give a mechanical assembly for vehicle which is comfortable for riders. So this is not a divisional application. I think you remember the divisional application that I said, that we cannot claim many things in a single innovation. We have to file separate patent application for separate innovations, but here you can see they are all united, supporting to each other, and there are different ways of preparing it. So patent office allowed it, because the purpose was to prepare a mechanical assembly. Another implementation, they have made some changes. They have made a rooftop positioned over the vehicle body, rooftop connected to upper edge of the windshield, and rooftop may be detachably connected to the upper edge, so that it could be detached also. And tools are what? Through which tools they are connected, you have to write down which tool exactly you are using. Because somebody may prepare the same using some other tool, and you will be clueless in that way. So you have to write down which tools you have used. Even they have mentioned bolt, screw, pipe, clip, bush, everything they have written. When the roof top is made up of which material? Soft fiber material, and soft fiber material may be lightweight. It could be little bit heavyweight, it could be lightweight. So could be, maybe is a word that can give you a scope of incorporating more. If they have written soft fiber is of lightweight, so somebody else could have prepared it using a little bit heavyweight, and can prepare the same innovation, can prepare the same product. Okay. So it will be difficult to exclude, means market monopoly will be difficult. Others can prepare, and you cannot sue them for infringement. Why? Because in your patent application that it is only lightweight. So others can prepare using little bit heavyweight, not as lightweight as yours, but you cannot like sue them for infringement because they are actually not infringing your application. You have not mentioned that in that way. Third implementation, what they did is like mechanical assembly may comprise a mud guard positioned below and in front of the vehicle body. So it needs to be mentioned below and in front. And mud guard may be connected to lower edge of the windshield, maybe or may not be. So the scope is still there. Mud guard may be detachably connected to the lower edge using the tools consisting of the group existing of bolt, screw, pipe, clip, and bush. So everywhere it has to be mentioned how to connect, where it is positioned, of what material it is made up of. But in writing that, always remember, if the materials are of different kind of, and you are writing just one kind of material, you are leaving a scope for others to prepare the same product using slightly different material. So if possible, you can use the word maybe, could be, so that others cannot use directly that. Simply meaning you could use that, you could use even the heavyweight. So yeah, you are covering lot many things. So this is the beauty of writing the summary, where you are actually covering. You will have a big coverage so that others may not be allowed to prepare the same product. Now the drawing. This is the drawing that has to be prepared in this way, and it has to be labeled by the numbers. Number 1, number 2, number 4, 5, 6. Every part should be labeled. Drawing should be in a proper dimension paper, should be like a sketch. Nowadays even printed could work. So drawing must be done. Drawing is important whenever mechanical assemblies are like filed for patents. Why? Because patent office wish to see that. And also it is important that somebody else cannot prepare in the same way. Whenever drawing is submitted, a drawing has to be filed by attachment on a separate file. So a separate file has to be made for the drawings, and it should be filed on the portal separately. Or if paper filing is done, it should be documented separately. Then comes the brief description of drawing that is in the patent application. You have to describe what is part 1, what is part 2, what is part 3. Completely describe your drawing with respect to elaborations. And reference number must be there, which identify the figure in which the reference number first appear. Clear? The same numbers are used throughout the drawing to refer like features and components. So numbers must be given. So figure 1 just have illustrated a mechanical assembly for vehicles, connections, all parts, and they should be written like what is your part 1, part 2, part 3, all illustrations must be given. The next point they have mentioned is the detailed description. Detailed means like everything about your innovation and how did you make it actually. So here they have written that there is an arrangement and connection of the components of the mechanical assembly for vehicles, which is described here, which is consisting of component like windshield, rooftop, mudguard, and they are connected to a vehicle for providing safety and comfort to a driver. So they have first written the composition, then they have written the what is the purpose of preparing it. And after that, they have written like all the methods of implementation. Like while aspects of the described mechanical assembly for vehicles may be implemented in a number of configurations, They have given three way of implementation it. The embodiments are described in the context of the following exemplary system. They have to given a way through which it has been prepared. So referring to figure 1, components of the mechanical assembly for vehicles, 100, this much, this is the number given, and the connection is illustrated in accordance with the embodiment of the present subject matter. So it is in accordance, it is according to the embodiment of the subject matter. So you have to say that, yes, my drawing says that this is composed of these many parts, and these parts are in the embodiment of my invention. So there are three embodiment. We have just studied three way of implementing it. So first embodiment, they are saying that in one embodiment, mechanical assembly for vehicle 100, this is the name given, may comprise of a windshield. Windshield may comprise of a glass window connected in center of the windshield. The glass window may be connected to the windshield in an airtight manner using rubber fittings, and windshield may be positioned above and in front of the vehicle body. So you have to write how they are working together. This is the unity of invention that has to be given. They have not listed the components. They have written how one component is supporting, connected to each other, and giving a common innovation. What is your common goal? To do this, you have to prepare, arrange, and connect the component of the mechanical assembly for the purpose of providing safety and comfort to the driver. So how you have placed, where it is placed in front or the back, how they are connected to each other, that has to be described. Then the windshield that you have mentioned here may protect the rider from incoming breeze, dust, rain. What is the purpose? That has to be written. And it should be made up of acrylic material. Acrylic material may be transparent. They have written here also, may be transparent. So it could have some translucent, if some translucent windshield is prepared, still then it could be accepted. But yes, that has to be proved that rider must not have any discomfort using that. The glass window may provide visibility to the ground ahead of the vehicle. Okay. So the language must be like this. If you are giving a very good challenge, the glass window will provide a definite visibility to the ground ahead of the vehicle, and suppose it is not giving so much visibility, a little bit, even a hitch is there, this claim will be invalid. Okay. So it depends on perception also. Somebody says that it's quite visible, some person says that it's not visible to me, and if they claim and to the consumer court and somewhere that its glass window is not visible, so innovator must not be in problem. So that's why they have written such sentences, may provide visibility. That if somebody is like it is destined to provide, is aimed to provide, it will definitely provide. It will be like a liability on the innovator to definitely provide you the visibility to everyone, even the person who has a weak eyesight. So it's like the language should be said that yes, I can give you, it can be done. So in that way it should be written like this. Even if you are very sure that my windshield is transparent, it will have the 100% visibility, you shouldn't write such kind of sentence that it is a 100% visible system. Clear? May be transparent, may give comfort, in that way. Detailed description, then they have written about the wiper, because nothing should be left, everything should be written here. So they have written about the wiper, how it is connected to the motor of the vehicle. Motor actually actuate the wiper. Okay. The wiper upon activation may wipe the glass window. The wiper may be used for wiping off dust and water settled over the glass window. So what is the purpose of wiper? How it is activated, how it is working, it is written. Then they have written that in one embodiment, the mechanical assembly may comprise a rooftop. Then the next way of implementation they have described in the description, that is about the rooftop. Rooftop positioned above the vehicle body may be connected to upper edge of the windshield. So suppose whenever you have filed this patent application, but while working, you think that if you connect something to some positions, it's not perfectly working, you can change the position to little bit. So in your patent application, you must leave a scope of little bit modification in your product. You shouldn't be so stringent. So these words become very important. May be connected, may be positioned above, below, all these things. So that even if you slightly change the positions, you have the scope of changing it. So the rooftop may be connected to upper edge of the windshield, may be detachably connected to the upper edge of the windshield, or and the roof tools selected for attachments are bolt, screw, pipe, clip, and bush. So they have written all the things through which they can do the connections. The rooftop may be manufactured from which type of material? You can write here soft fiber material, wherein the soft fiber material may be lightweight. If somebody says that, I'm not feeling it lightweight, I'm feeling it heavy, so you should be writing in that way. Yes, it may be lightweight. Even if you are 100% sure that anybody can like lift it, it is very lightweight, but still you have to write in that sentence. Then rooftop may provide a shade to the rider and protect the rider from sunlight and rain. Rooftop may block the sunlight and water from reaching the rider and thus protecting the rider during a sunny day and a rainy day. Okay. So here also they have written may. So they may protect. So if somebody still have some complaint and recalls, but your innovator will be at a better position. So these are some legal terms that we should keep in our mind. Another embodiment about the mudguard they have explained, that is positioned below and in front of the vehicle body. Mudguard may be connected to lower edge of the windshield where it is connected, may be detachably connected, and how they are connected using bolt, screw, pipe, all these things. And mudguard may be manufactured from flexible polymer sheet, that may protect the rider from dirt, water, mud, and insects. So in that way, they have described what the material of the mud guard, the connection of the mud guard, the tools for connecting, the position of the mud guard, like this. So in this way, it should be written. You can see anybody can read it and prepare the product. So patent office wants such kind of description, that if still any person from any domain can read it. But actually the thing is that a mechanical engineering student, if they read it, they definitely can prepare the product. So the description must be written in that way. Now comes the claim, which is the main body of the any description. So how they have claimed it? Just see here, the same way you can practice for your innovation. So the independent claim, which is covering everything in a broad way, so that later on we can uh, like lie down other claims on our independent claim. So first independent claim, it is a mechanical assembly for vehicle, which is a preamble. I think you can remember the word preamble. Then comma, then come the transition phase, that is the said mechanical assembly comprising, clear, then colon, and after that the body of the description. So the body is a windshield comprising a glass window connected in center of the windshield in an airtight manner. Then semicolon they could have kept here. They have kept here semicolon, wherein the windshield is positioned above and in front. Then semicolon, they have written about the rooftop, where the rooftop is positioned. Okay. Then semicolon, they have written about the mud guard, how it is connected, wherein the mud guard is connected to lower edge of the windshield. You can see here all the parts, your mud guard, rooftop, windshield, all are well connected to each other. They are not just listed that said mechanical assembly comprising a windshield, a rooftop, and a mudguard. If they could have written, patent office may have raised some objections, because this looks like they have just assembled three components. Clear, windshield, rooftop, and mudguard. But see here how they have connected each of the component with other component to make it a unity of invention. So it should be written in that way. So all the bodies and how they are connected, supporting to each other, give a good independent claim. And you can see here in the independent claim, they have covered everything, actually in just one sentence. So this one sentence could be even a page long. So many, because this is a small firm, many bigger firms, whenever they file the patent application, their one independent claim could be even a 1 page long. Clear? But this is a single sentence. And they have connected all the parts, all the components using semicolon, and yes, connected each of the component by supporting each other components. They support and connect, they correlate in that way. So this become your independent claim. So in that way you can write it. So yeah, some questions are coming. I will come back to you definitely. Let me complete just first. I think many people might be concentrating on that. So we will complete and definitely we will solve all the queries. So that way you have to write the independent claim. Then come the dependent claims. Now remember, whatever you have written in the independent claim must be described in detail. Must be described in such a way. A claiming means what? I claim, we claim. So others may not produce the same. Whatever I claim will be my monopoly. So just imagine what you write here, rights will be given for those parts, whatever you write, whatever you claim. Suppose you have left or forgot to claim something, you are leaving a scope for others to use that. So if you wish to exclude others, because in companies, whenever they market something, what they want, they are exclusive right in the market. Nobody else should be like them. Then only they can earn. That is the point. If like 4 products are there of the same kind, consumer will get confused. They may take this, they may take that. So what will happen? Supply is more. Market is still the less. So there will not be a benefit for the innovator. So how to make it different means you have to cover, you have to exactly make it in such a way, claim in such a way that others may not produce the same kind of product using same component like you. So the dependent claim they have written, it is written like this. The mechanical assembly as claimed in the claim 1, normally we write as this, or you can write like this also, the mechanical assembly of claim 1. Then a comma must be given, wherein is the connecting phrase here, wherein the rooftop is detachably connected to the upper edge of the windshield using the tools selected from the group consist of bolt, screw, pipe, clip, and these things, and possible list of tools. They have written all the possible. Suppose somebody have not used these 4 tools and connected it using some other tool and claim that no, you have used these 4 tools only, so have used some new tool and now my product is different from you. Somebody else can say. So what they have done, they have written and possible list of tools that may be used for connecting and brush. So definitely it's very important to write here that you write what are the possible tools, because this is such an important and small thing that they can prepare the same product like you, just changing the tool and say to the patent office, no, they have used that tool but I have used another tool, so definitely my product is different, I will market it. And patent office can't do anything because you have not claimed. So claim like this, what are the possible tools. Then the third claim they have written, the mechanical assembly of claim 1. Now they have written about the mud guard. See, they have written the mud guard is detachably connected to lower edge of the windshield using the tools selected from the group and also the possible tools. So in the third claim they have written about the mud guard. In the fourth claim they have written again about the windshield. The mechanical assembly of claim 1, wherein the windshield is manufactured using acrylic material and wherein the acrylic material is transparent. Here they are claiming a transparent acrylic material. Clear? Because the windshield must be transparent. If it is translucent, if it is dark, it will be very difficult and it may not be allowed also. So they have claimed a transparent one. So they know that nobody else will prepare a translucent and they will be better than them, because everybody will prefer a transparent windshield. So here they have just written transparent. Clear? Because that is the need of that. They know that nobody else will prefer to prepare a translucent. Clear? Again, they have written in the claim 5, the mechanical assembly of claim 1, wherein the rooftop is manufactured using a soft fiber material, wherein the soft fiber material is lightweight. Here you are claiming, what you are claiming exactly is very specific. Yahan pe maybe, could be, it is not tolerable. Clear? So here you are very specific that it is a soft fiber material of lightweight. Clear? So if others are preparing, they may not prepare, they will not be allowed to prepare a soft fiber material using a soft fiber material and product, lightweight product. So they can prepare a hard fiber material or a heavyweight product. So definitely you will be always better. Okay. Again, in the 6th, they have described about the mud guard, the mechanical assembly of claim 1, wherein the mud guard is manufactured using a flexible polymer sheet. They have written a flexible polymer sheet, any kind of polymer they can take, which is a flexible sheet. Okay. So somebody else is preparing, they cannot use a flexible polymer sheet. Clear? So somewhere patent office may raise the objection. यहाँ पे एक loophole है that I wish to point it out. They have written flexible polymer sheet. You know, there are n number of flexible polymer sheets. So patent office may raise an objection. I think here they have surpassed this objection. They might have pleaded something what in the telecon or like in front, but it is covering actually many of the polymer sheets, and like they have not specified exactly. So actually they are preventing anybody from using the flexible polymer sheet, and there are n number of flexible polymer sheets. So see how they are monopolizing the product. So patent office want that definitely should monopolize, but you shouldn't inhibit in such a way that nobody can use a flexible polymer sheet for such kind of innovation. Suppose if you are seeing this innovation and trying to make an improvement in this innovation only, it will be a kind of like a barrier, a big barrier for you. Wherever you, if you wish to prepare a mud guard for such kind of innovation, they have written a flexible polymer sheet. So definitely you cannot take a very hard, very like tough polymer sheet. You also need to use a flexible polymer sheet. So that's why here they have covered very, means like their coverage is big. Then comes the another claim, that is mechanical assembly of claim 1, wherein the windshield may comprise a wiper connected to the motor of the vehicle for wiping the glass window. They have just covered the wiper in a very simple way, that it may comprise a wiper, because you know this is such a system where it is very common for every of the vehicle. Wiper is already very common one. So they have claimed like this. So the overall composed become, sorry, the overall composition become a rooftop, mudguard, and a windshield. Their connections, their tools for connecting, their material, which material they are made of, which kind of material they are made of. So their claims are only 7 claims. The product is in market from that Pune based firm. They might be earning very well for that. I'm not disclosing the name of the firm, not even the product, but the patent application is like this. But I think if it is in public domain, so there is no need of like not disclosing. I will disclose it to you. That will be better for you. So abstract. Now abstract is made up of 150 words. So it discloses a mechanical assembly for vehicle. Mechanical assembly comprises mechanical components like a windshield, rooftop, and a mudguard. And mechanical components may be detachably connected in a suitable manner. Mechanical components may be attached with this is an abstract. Actually writing everything about the innovation, but not in a very elaborate way, just in an abstract manner. So here the patent application actually ends for them. This is a granted patent application. Whenever we see on the Indian Patent Office website, and we see for the public search, we can search by filling many of the like criteria, like innovator name, patent application number, patent number, title of innovation, anything which may be in the abstract or in the description. So while searching, like patent application will be displayed. Whenever you click on the status of patent, then this status will be displayed to you. So here you can see application status. They have written this is a granted application. Patent number is given. And nowadays, this is a very recent advancement in the on the portal of Indian Patent Office, that they display every status. Means patent filed, then this will be green, others will be white. Then RQ filed, request for examination, then your publication, under examination, disposed. Everything is being displayed on the portal about the status of the patent. So this is a disposed patent application with the grant with a patent number. See, this is a mechanical assembly for vehicles. In the patent search, it is now being seen like this. Publication number is this, publication date, publication type, Indian, application number, application filing date, field of innovation, classification is also given, and this is the certificate of grant of the patent. that is given, and here they also write down the term of 20 years from the date of filing. So you can see here the date of filing is 22nd May 2014. They write here 22nd May 2014, and they count the tenure of the patent from this date. So 20 years from date of filing. Okay. So you can see here they might have taken some like years to get it. You can see here that the date of like filing. Date of filing here becomes very important, and the patent number is very important. Okay. If if expedited processing is done, it normally takes 6 months to 7 months. If normal processes through normal process, it takes about 4 or 5 years actually, because publication takes about 1.5 year. Then examination, normally if people apply within 48 months, within 4 years, so again that 4 years time is there. So if you go through a very normal process slowly, it take about 4 or 5 years. Through expedited processes, it can be done within 6 to 7 months. Now another patent application that I wish to share with you what was a smart helmet, just to give you claims how they are drafted. There is a smart helmet for a vehicle having an engine worn by a driver of the vehicle having a wireless communication with the smart helmet, the smart helmet comprising. See here, this is a single independent claim of 1 page, where they have written every component of the innovation separated by semicolon. A microcontroller, a switch, a panic switch, alcohol sensor, the light dependent resistor sensor configured to detect high beam light, a GPS module, everything. This is one independent claim. But you can see here they all have connected to each other. Means it is configured to provide on-off signal, module configured to sensor amount. So it seems like all are just for making a smart helmet. So in this way it is written. The dependent claim, now again elaborating every component of the independent claim. So they have written in the claim 2, smart helmet as claimed in the claim 1, the way I write here. Nowadays, nice systems are being more improved. So I write in this way only. The smart helmet as claimed in the claim 1, further comprising a camera configured to receive live videos, feed amount from the driver wearing the smart helmet. Then again, they have laid down this claim 3 on the claim 2, that smart helmet as claimed in claim 2 further comprises a user interface in communication with the microcontroller configured to display location of semicolon, receive the display of video feed, semicolon, and के साथ they have joined it. Receive statistics from the vehicle and display the plurality of statistics. So in that way they have like elaborated, covered. You elaborate, you cover, you are leaving a scope. So always remember, be specific in writing the dependent claims. Write down exactly what you are using. And if you feel that like I can cover something more, definitely you should cover, but do not cover in such a way that it become look irrational. Clear? So the fourth helmet as claimed in the claim 3 further comprise they have elaborated one by one. So in that way, it's a very good innovation actually, smart helmet. And so now it is vehicles. There are a lot of innovations. I'm giving you brief insights about what is the mega trend that is being followed in the mechanical engineering. So nowadays, what is the mega trend? That is the CESS, connected, electrified, sustainable, and safe automobiles. So that mega trend is being followed by Tata Motors, and it's proud for us that Tata Motors started its drive for engineering excellence and innovation in 2020 by filing 80 and receiving 98 patents in 2020. They have received 98 patents, that is a record, and for best in class make in India products, and that offer global standard designs. So 98 patents in a single year for Tata Motors have been there. This Tata Nano car is protected by 200 patents. So they have filed 200 patent application to protect each and every component of that car, because all components have very innovative features, and they are combined in a combined way protecting the Tata Nano car. So in that way, it could be done. Another indigenous brand, TVS Motor, that is the best one. It has been filing more patents than Tata Motors and Mahindra and Mahindra. So first one is TVS Motor, then Tata Motors, and then Mahindra and Mahindra. But these three are the indigenous brands that are actually filing increasing patent applications day by day. Trend kya hai? Now patent filing in the automobile sector, automotive sector is more towards AI integrated vehicles, vehicle control system, and ancillary vehicle system. VANET is also a very good project. So in that way, it could be like more and more like this CSS concept could be adopted, because like trade, but these are the way of innovating it. Recent trends. So in 2019, 20, actually this is 2019 to 19 because from to December, about 6 of things patent were filed in India, of which over 5,000 were filed in the last 5 years only. So IoT is a great field nowadays. Now, 80% of these patents filed were related to applications pertaining to industry with the healthcare and automobile industry. So I think the newer innovation must incorporate these things if possible. Indian patent applicants are Tata Motors, Mahindra, and TVS. Nowadays, TVS Motor is aheading from all of them, and then Tata Motor, then M&M. Comes the substantial number of patents that has been filed by Indian automobile manufacturers fall in the category of areas like arrangement or mounting of propulsion units, transmission systems, instrumentation for vehicles, arrangement in connection with cooling, air intake, gas exhaust, fuel supply of propulsion units in vehicles, etc. So these are some of the fields in which the mega trend is going towards. So whenever we see the patent applications, now major patent applications are like this. Why? Because justifying the innovative features are very easy now. Because whenever you enter in a new field, it will be really a niche market. Niche market means others are not there. You are the only one. So it will be very easy to get the patent. And definitely these products are so lucrative, like the innovator may become a millionaire, billionaire like this whenever they get the grant of the patent. So if some student is working over such kind of project, definitely they should go ahead. Patent office actually welcomes such kind of product, and there are a lot of scopes. So it is pertinent to mention that Indian automobile manufacturers are also undertaking some more research in the field of computer technology for automobiles, in addition for improving upon the mechanics of the automobiles. So yeah, there must be some combined projects between different departments. They can combine their expertise and can bring out something more better, as the Tata Motor, Mahindra, and TVS are doing. So they are actually doing all such kind of innovations. So I expect that the session might be useful for you. Created some kind of curiosity about you, and you might be very interested in protecting your innovative features of your innovations by drafting your claims for the innovation and filing a patent application. If you have any query, you can ask me. Or if you have any doubt, you can definitely contact me. Because I'm there only to innovation policies, and I also help students in IPR filing. Even the faculty members and innovators are well connected to me, because I support them for like filing their patent application through e-filing, and I spread awareness among all of you actually. Patent must be a part of the curriculum now. So everybody should think of filing the patent and then to publish their innovations too. So if you have any doubt, you can contact me at my mail ID, or number is also given, no issues with that. And definitely I wish all of you to innovate, patent, produce, and prosper. That is the sentence given by our Prime Minister Narendra Modi. And basically, whenever you do any research, you should protect your innovation, commercialize it. You can license your innovation to some company also. They can give you a royalty in return. If you are not able to open your own firm or to commercialize your own product, you can even give license to some other firm, so that they can commercialize and can give you royalty in return. So yeah, that can also be done. That is a way through which you can proceed. So please, if you have any questions, you can ask me. I will be happy to answer your queries.
Ma'am, this is Nindita Ramesh. Hello.
Yes, yes, ma'am.
Ma'am, how many maximum number of applicants is permitted in an application?
Maximum number of innovations.
No, applicants. No.
Applicants, okay. Applicants
Yeah.
can be many, ma'am. Actually, I have filed even using 10 applicants.
Okay, so there's no upper limit like that, or I mean, it should be restricted to some.
I hope like 10 people are working over it. Usually,
Yeah.
10, 11 I have filed. So I think there is no
Okay.
issues with that.
Right. Okay. Thank you.
Thank you.
Hello, ma'am.
Yes, yes, sir.
Can you take one case study regarding the patent search, if possible?
Yes, I will do. What's
Yeah.
the time now? Okay, I can spare some time over the patent search. Is there any other question?
Also, in brief, if possible, can you explain the importance of claim and its syntax specifically? In brief.
Okay.
Yeah. Thank you.
Syntax actually yesterday I had explained. I'll go back and explain the syntax and then I will go to the patent search. Definitely. So I think I will complete this within 10 minutes. Then I will undertake some more questions. Is there any other question that anybody wish to like ask so that I can proceed further for patent search?
Ma'am,
Yes,
in
yes.
background you told that we have to cite the patents, but is it also required to cite the journal paper if these journal papers are related with your innovation?
Yes, you can. You can. Actually, patents must be cited. Some journal papers, if you are citing, that can also be done.
Okay.
But you
Okay.
know, journal papers are normally patent office considered that they're not to be commercialized. So they prefer that if you cite some patent. Because you know, patents are for commercialization. So journal paper publisher normally never sue anybody for infringement. So you can definitely cite the journal paper. Even patent office also give examples of journal papers that your product matches with the earlier innovation. You can definitely, but patents are more important to be cited.
Okay. Okay. Thank you,
Yes,
ma'am.
yes, yes, yes. So, so any other questions? So that again, I can again go back to patent search or claim drafting. If somebody has any question, they can ask first. Okay. Okay, fine. So I'm giving you a brief insight about the patent search, and again I will explain you about the syntax. So I think first I will go back to the syntax part, and I'm giving you a brief insight. Just a minute. I hope the slide is visible to you, and you can see the patent claim format.
Yes, ma'am.
Yes, ma'am.
Okay. So here, the patent is being written like this, like the preamble. Preamble is the actual product or the process. Clear? So what exactly your product is? It is the preamble. It is separated by a comma from the transition phrase, which could be open-ended or a closed-ended. So if I say comprising, it means it comprise of this. If I say containing, so it may contain this, but it may contain some other components. So that is called as an open end. We are leaving the scope. Yes, it contain, but it may have some other. I'm not closing my innovation to that body only. But if I say essentially consisting of, simply meaning my innovation is essentially consisting of these components, not any other component. So that become a closed end phrase. So I write first the preamble. Then we separate the preamble from transition phrase by a comma. Then after transition phrase, there is a colon and then the body of the claims separated by semicolon like element A, element B and element C. But we don't, it is not good to just list out the components. It is important to connect the component with each other so that it seems that your product is actually dependence of one component over the another. All components are supporting each other, they are correlating each other to give you a single product. For example, this is my preamble, a computer, separated by comma with the transition phrase that is comprising. It is open-ended because here if you write this, but other components may be there. Then a colon, then all the body of the your claim separated by semicolon, like a processor, semicolon, a memory, semicolon, and a bus configured to transmit the data between the memory and the processor. So simply meaning the third line is actually giving a statement that your processor and memory are well connected in a configuration. So in that way we write the claim. So this is the basic syntax. And in that way, there are many examples, like an apparatus comprising this component, then semicolon, another component, wherein the cover is detachable from the binding. So some sentences are actually connecting all the components together. And this is the unity of innovation. Aim is to give a product, an apparatus. So in that way, it has to be written. So this is the claim syntax. Now, I will go to the little bit about the patent search. Okay. So patent or prior art search. There are many ways of search by which we can find what is exactly similar to our work that has been done in the past. So top 5 patent search strategies are key string search. Key string means you write just the name of the components, key strings that can give the similar results. Patent classification search, where there is a classification number and you can get a list of patent. Citation based search, assignee based, who is the assignee, and inventor based search. So you can even write the name of the inventor and or the name of the company. Suppose I wish to find the patents filed by Tata Motors. So that is can come under the assignee or the inventor, through which I can see. Citation based search I can do, or key string search is done by all the student and faculty innovators, or the natural person startups. They do the key string search because they wish to know what exactly in this field or in this domain has been done. So see how it is done. First of all, identify the word that define the feature of the innovation. Clear? So suppose I am writing a mechanical device. So this is the word that is defining a feature of my innovation. Now find out the synonym of that. All synonyms that are related to your product. List out the synonym. Normally in normal like free softwares like Google Patents or WIPO, we have to do it manually. But in some paid softwares such as Patseer or like Dolphin, we can have this facility that synonyms are automatically given to us, and they do the synonym search by themselves. The software can do that search. Then synonyms are combined with the use of or and Boolean operators. So suppose if I have a synonym for search query, which for attach or secure. Okay. So the word attachment or securing is almost have the same function. So search query, if I write attach or secure, clear, it means it will give me documents which have either attach or secure. If I write attach and secure, it will give me all documents which are attaching also and securing too. Means both the word will come in a single patent application. Just for example, if I write a search query such as attach or secure, and then I add and in between and write rod or bar, it will return all the documents which have patents with attach, okay, with secure, and with rod or with bar. Clear? So I will have n number of components, and it will be very difficult to go through 50,000 documents. So you can have an idea, yes, there are 50,000 documents, but now I will have to find what exactly similar to my product. So now I will narrow it down. Okay. So now I will write attach and secure and rod and bar. It means it will give me the document which have all the 4 words together in a single patent application. Okay. So in that way we can do the search. So also we can add these queries in our title. If the title contain all these 4 words, those documents will be given to us by software or the database. Or if we write title in abstract also, so even if these 4 words are not in the title but in the abstract, documents will be received, because in abstract these 4 words are there, and I will get the documents whose abstract contain those 4 words. Now see, suppose what is a good search, what is a bad search. First thing is that mobile phone. What are the synonyms of mobile phone? Cell phone, cellular phone, hand phone, portable communication device. These all mean handheld communication device. All these are there. So a poor researcher, what they do, they will just put the word electronic device. So what could be given to them? Even 1 lakh documents they will receive. How 1 lakh document could be gone through? It's very difficult. It's a very broad search. Never search in a very broad way. It will be difficult for you to go through the patent applications. They will give you 26,000 applications. Narrow search, if I'm just writing a handheld communication device. If I'm writing this, means just a mobile phone which could be held by hand will be given. Any other device which it just could be kept on the table, and like any speaker phone will not be there in our documents. So you can get just 1 or 2 patent application and you will cite them as your prior art. Is it really good? No, it is too narrow. You can write mobile phone, definitely mobile phone, because you can carry, you can move on without holding in hand, using Bluetooth, you can use it. So the way by which the things can come. So just remember, search in such a way that it should not be too broad, too narrow, so that a good search can be done very meticulously. Patent search platforms, these are free platform: Google Patent, SpaceNet, USPTO, Web Patent Database. Yes, all are hyperlinked. In past, lens.org. Paid database are Derwent, Patbase, Patshare, good one that I use, Drug Patent Watch, PatSnap. So these are paid databases. So here the like synonyms, additions, documents, it's very easy to do, and like things work very smoothly, very fastly. Google Patents will give you many data from all these patent offices: US, China, Europe, Korea, Dutch, Canadian, and you will get all the data from all. Google Patents are very good for students working over the patents. Suppose this is the Google Patent. This is the site, you can see here, patents.google.com. Here it will open like this, Google Patent. Suppose I am writing here the most common innovation, toothbrush. See here, results, 62,139 results for toothbrush. Okay. So here there is a system by which we can add or plus synonym for toothbrush. Okay. Or we can even refine the results using inventor or assignee or patent office. So if I wish to search it in India, I can search. Language, you can put the language, you can status type, all these things can be done. What I did, I added toothbrush and oral hygiene, both, because these are synonyms. Results 20,000. So toothbrush only have given me so much, but if I have just added one synonym, oral hygiene, they have narrowed down the results. Because not only a toothbrush, but for oral hygiene product. This is the result. Now see, one patent application I just clicked on, hands-free oral hygiene system. Okay, because oral hygiene may be hands-free. You know, it may not be like a toothbrush holded by hand. It could be hands-free hygiene system. So it is also given here. Hands-free hygiene system has given some of the findings. What is important? Oral. Why? Because I have added oral hygiene. So wherever the synonym I have put in my search, that will be highlighted in the patent application. So suppose what exactly you are doing, you want to see in the earlier prior art, that will be highlighted in the prior art in the patent search. So write down all the synonyms. those synonyms will be highlighted here, and you can match whether my product is the same or not. If what you have added in the search is not here, it means you are novel. If it is here, you are not novel. Then comes the WIPO, patentscope.wipo.int. Simple search is there. I have added one product. It has given me some results. Okay. This is only this is my patent only that has been published in WIPO. And world patent. WIPO is why it is called as world patent. I filed in India, but I can see on the site of the WIPO. So this is our product only, and you can see here. You can have the search way by which you can even assign the companies. I have assigned PCT. So all the patent applications which have gone through PCT route will be given. If I write all national applications as well as PCT, all applications will be given back by the WIPO site. So you can assign, you can see if it is patented in Canada, Argentina, Colombia, where it is patented. But remember, you want to market in India, but it should not be reported in the world. Clear? To protect the novelty. So it's very better to do the patent search using all. Search whether the invention has been filed in a national filing phase or PCT phase. All applications will be given to you. So you can see here the WIPO has given this document. What I have added in the search, penetration enhancer vesicles. So everywhere it will be highlighted. And yes, I can see that if somebody else, suppose you want to do a patent you are working on this particular project and you are searching, you will get my patent application in which these words are there. So definitely you cannot prepare the same product, penetration enhancer vesicle, because it is already there in the public domain. So if something is in public domain, it is not patentable. Okay. So you are able to see this, simply meaning it is in public domain. So do something different, definitely. Or what you can do, you can go through my patent application, find out what exactly I have not done, find the loopholes, write it perfectly, and say that they have prepared this PE vesicle. I'm preparing PE vesicle in another way using another component which is better than this. Then it can be done. Indian Patent Office also you can go through. Patent search, public search, you can go through the patents. Then you can write the title. You can even write in abstract, complete specification. All these heads are there. And this captcha code, and then you can get the patent applications. You can see here in Indian Patent Office, we are available. In other, even on the WIPO site, we are available. Here you can see application is published under examination. Even on the Indian patent site, you can have many examples of patent applications. Suppose if I'm adding here just toothbrush. So in India, 349 applications on toothbrush have been filed. Okay. And they're all published. You can go through them by clicking here, find out the loopholes in them, jot it down. Okay. Here I have added toothbrush in the title, and in the abstract I have added oral hygiene. So you can see here, like there would be a lot of applications that can come, but if both are there, so simply your your search will be narrowed down. It will be narrowed down in that way. So even if I write in complete specification the bristles in the toothbrush or a kind of angular toothbrush, so only angular toothbrush will be given to me. So I can narrow it down in that way. So this is something about your patent search. Actually, this is again a big field, and it takes about 3-4 hours to explain you exactly how patent search is done. I think I've given you a brief highlight about it. So if you have like any further question, you can ask me, because it is important to clarify your doubts here. So any questions, please? Any interaction? Yeah.
Hello, ma'am. Can we get more information about product documentation, patent documentation?
Yes, yes. Can you please repeat? It's not audible. Hello?
Am I audible?
Yes, yes, yes.
Can we get more information about patent documentation?
Patent documentation means exactly patent documents are the forms. The form 2 is your document. And what I explained to you, what a patent document contain is the basically your what you write in the form 2, that is your detailed description, then your innovation summary that are in the form 2. And form 3 that I explained to you is the document for like information to patent office regarding foreign filing. Form 5, when applicant and innovators are different, then applicant has to declare that this particular person is the innovator. Form 1 is the application for grant of the patent. So these are the basic documents. Beside that, Form 26, power of attorney, then renewal of patents. There are several forms like this, several sections. Actually, n number of sections and rules are there, and they define many kind of document. But what is required, I have explained to you: Form 1, 2, 3, 5, and Form 26. Yes.
Thank you, ma'am.
Yes. Further, any question from anybody?
Any question? Any question from participant?
You can contact me later also if you have further questions. I think I've given you my mail ID. You can contact me. Any of the participants, if they wish to contact, they can ask later. They can definitely contact.
Yeah. I think there are no questions remain to ask. Ma'am, thank you very much for giving your good session. Really, we come to know that how we need to go with the patents filing, which are the different areas in mechanical engineering and as well as other allied domains in which we can have to file the patents. So once again, from my side and my institute, thank you very much, Dr. Prachi Pandey, ma'am, for your valuable time given to us.
Thank you.
Surely the session helps to all participants to file their own patents in future. Also, I would like to thanks our Pimpri Chinchwad Education Trust, our management, director sir, head of department, R&I dean, and our R&I coordinator for always supporting and encouraging such a events. At last but not least, my all dear participants, those are interested in the IPR filing, and we all hope in future all of you will file at least one patent in coming days. And at any point of time, if we face any issues, then definitely we will be having the contact with Dr. Prachi Pandey ma'am, and accordingly we take some guidance from her. So once again, thank you very much, Prachi Pandey ma'am, for giving us your time. Thanks a lot.
Thank you.
Uh,
Thank you. Thank
yeah,
you.
and one notification for the participants. I think that feedback link is not working. So what I will do, I will share the feedback link on your mail. I will see that what technical issues at the background. And I request to all participants, please fill that feedback form by which we come to know where we are lagging and whether we want to conduct such a type of events in future or not. So thanks a lot, all participants, for joining these 2 days sessions. Thanks a lot. Thank you very much.
Thank you. Thank you very much.
Thank you.
Yes,
Thank you,
my
ma'am.
pleasure.
Thanks a lot. Yeah, thank you.